All right, this is our third video. We're still on week one, and what I'd like to do now is go over the handout called Court Terminology. You will be required to brief 4 cases as part of the work produce that you have to do for this course. And again, we'll talk about that a little bit later on. Probably in one of the live sessions, I'll go over how to do that and what I expect. I do have a brief summary of what types of things should be in a brief, and I'm sure for many of you, particularly those of you who are paralegal majors, you've dealt with briefing in your legal writings and research courses, and it's all basically the same with a little bit of differentiation between each professor having their own thing that they like. However, I would like to go over some court terminology so that as you're reading cases, both for this course and in the future, you'll have some understanding of what is going on and be able to better analyze what's happening and understand what the court's doing and what they're saying. Okay, so beginning with that handout, certiorari. A writ of certiorari is a petition to the Supreme Court to hear your case, with very few exceptions. Such as when a state sues another state, the Supreme Court does not have required jurisdiction, which means that they can decide which cases they want to take and which cases they don't want to take. And actually, they turn down the vast majority of cases that are presented to them. The way that you get your case to the Supreme Court is after you have finished in whatever other court you were in and feel you have some reason to get to the Supreme Court, your lawyer has to file a writ of certiorari, which is really a petition saying, please hear my case. There are important legal issues here. Somebody needs to decide what's going on. The lower courts have mucked this up. They haven't done it correctly. And again, this is discretionary on the part of the Supreme Court, and the vast majority of petitions that are presented to them are turned down, are denied. Now, once the court hears a case, reads the briefs, reads the memos, they enter a decision. And there are several aspects, several parts of that usually. All right. They will vote. There are presently 9 justices, so it takes 5 to win a case. And whichever side wins, they get to write what is called the opinion or the majority decision, majority opinion. And what happens is whoever the senior justice is among those 5, that judge gets to pick which of the justices is going to actually write the decision, and that becomes the decision of the court. That's the actual official rule of the case. That's the one that actually sets precedent that we lawyers look at and say, oh, that's what we have to follow in the future. That is the most important part of the decision. Now, the judges who didn't agree with this decision, they don't just sit there quietly and lick their wounds and not have any say. They get to file what is called a dissenting opinion, and there can be one or there can be a number of them, because each judge who voted against this decision can write their own. And this is a written statement saying, this is why we think the majority is wrong. This is why we don't agree with them. They didn't listen to what was going on here. They didn't apply the law correctly. They didn't follow the Constitution. This is not precedent because it is not the case. It is not the ruling. However, in an area of law that's developing or changing, it becomes very important, because next time the 5-4 majority might switch the other way. So this gives the lawyers involved in Supreme Court litigation a kind of a window into, the majority said this, but the minority is really adamant that if we get the right case in front of them, they're going to vote the other way, and here are the things we need to look at. Here are the things we need to consider to get to that point. Now, the judges who are in the majority, even though they voted that, yes, this side should win the case, they don't always agree on how you get there legally. So very often you'll see something called a concurring opinion that's written by a judge who agrees with the majority. They voted that, yes, the case should be handed down this way, but they don't agree with the analysis or the reasoning that was used in the opinion. Again, this is not precedent. Only the opinion itself is precedent, but it's very important for lawyers to analyze this, because as we have cases going forward, it lets you know this is how this judge thinks about this is what they're saying, and that, gee, if certain facts were different, they might be on the other side next time. They might actually rule against this type of situation. A per curiam opinion is a decision reached by the court as a whole. It's not from one particular judge necessarily. Things that an appellate court, and specifically the Supreme Court, can do, but any appellate court can do, is they can uphold. This means that they agree with the decision in the lower court that's being appealed from, and they let it stand as a final result of the case. They could overturn, which means we do not agree with what the court did. They were wrong, and therefore the decision was incorrect. It cannot stand. Once they have overturned, they can do two things. They can make their own ruling as to what they think should happen in the case, and that becomes final, or they can remand the case. And remand means they send it back to the lower court saying, we disagree with what you did. You were wrong. Now fix it. Go back and do this. They very often remand in situations where they feel there was not enough evidence taken, or that evidence was excluded that should have come in, and therefore they wanted to go back to the trial court to basically do over again, to come and to apply the law correctly this time. And finally, what they can do is they can uphold in part, they can overturn in part. So particularly when you get into complicated cases, there are situations where they will say, well, we agree with the lower court in counts 1, 2, and 3, but we're going to overrule them in counts 4 and 5. We don't agree with what they did there. So very often today, particularly with the complexity of cases that has developed, you can see situations where they'll basically be playing both ends against the middle. We agree with you in part, we disagree with you in part. And then, once they've overturned, the part that they've overturned, they can remand for further action. A remedy is a redress for a wrongful action, a legal attempt to make something whole for injury or for a deprivation of rights. If you're injured, the way we usually try to make you whole is by throwing money at you, and by the remedy would be some kind of financial redress. If your rights have been deprived, there can be financial redress there also, but very often what we're seeking is an order to whoever is depriving you of your rights to cease and desist, to stop what they're doing, and to make sure that they never deprive you or anybody else's rights in that way. Again, habeas corpus is Latin. It literally means to have the body. It comes from English common law. It was called the Great Writ. And the English courts developed this system. You have to think about, it's hard for modern people to understand the system because everything has become so centralized and somewhat uniform in the present reality, and that was not always the case. If you think of the story of Robin Hood and the Sheriff of Nottingham back in medieval England. In medieval England, the king was the final authority. However, the country was broken up into a large number of dukedoms and earlships and lordships, different areas. And within the territories, those folks, the duke or the earl or the lord, had very much final control. They were basically the king within their territory. And so things went on where there were great injustices and great deprivation of rights that were acknowledged to belong to all English people by these feudal barons, these feudal lords and actors. So it could very well be that you rode through Nottingham and the sheriff of Nottingham arrested you and threw you in jail for something that was totally not allowed under general English law. Habeas corpus was an idea that said any judge, any king's judge in England can order any civil authority to bring a prisoner before them to determine if that prisoner is being justly held or not. So if the sheriff of Nottingham had illegally grabbed you and thrown you in jail as you were riding through his shire, your relatives, your friends, your lawyer could go to any judge in England and say, the sheriff of Nottingham is holding my person illegally. We want him out. And the judge could issue an order, a writ of habeas corpus, saying, I want to have the body, have them in my courtroom tomorrow morning, and we're going to investigate if they're legally held or not. And if you don't, Sheriff, you are in contempt, and we put you in our jail. So it is a very important right. It applies mostly to the criminal law, of course, but it is still recognized today. The Constitution, when it was drafted, made specific reference that the right of habeas corpus, which existed in the colonies, would not be revoked or abrogated. And about the only time it has been not observed was during the Civil War. Lincoln suspended it in some of the border states, the states that were between the North and the South, and really couldn't decide which way to go. And certainly in terms of World War II and the internment of Japanese citizens, the right of habeas corpus was not formally suspended, but it certainly didn't operate for those poor folks. If something is constitutional, it's in accord with the rights, duties, and principles set out in the Constitution and its amendments, and as it has been interpreted by the Supreme Court in the past. A brief is a legal memorandum that attorneys write to the court stating their arguments, their legal reasoning, applying the legal reasoning to the facts, so that basically putting their argument in writing to the appellate court. Jurisdiction, very important idea for any of you who are dealing with the law going forward. Jurisdiction, in its simplest, means the power of the court to hear a case and to hand down a legally binding decision. Jurisdiction is established through a few different factors. One is territory. We're going to find out when we get into property law. You and your neighbor have a dispute over where your boundary line is on a piece of property in Rhode Island. You both happen to be living in Massachusetts at this point in time, and both dealing with properties that you own out of state. You cannot bring your case in Massachusetts courts, even though it's more convenient you're both there, because the item you're dealing with is within the territory of Rhode Island, and therefore only Rhode Island courts have jurisdiction. So part of jurisdiction is determined by territory. Part of it is determined by connectedness. You cannot, if you've never been to you get into a car accident with somebody who's visiting here from California, you've never been to California, you have no intention of going to California, you have no business dealings in California, they cannot necessarily drag you to California to litigate the case there. You have to have some personal connection with the jurisdiction. Now, unfortunately, the federal court in California possibly could drag you there if the case is for a large enough amount of money. However, if you were selling a product, maybe a better example would be you make honey and you sell it at a local crafts fair, local flea market every weekend. And somebody from California happens to buy a jar of your honey. They bring it back to California. They eat some of it and makes them sick, and now they want to sue you. You did not make that honey in California. You did not put it on the market in California. You didn't advertise in California to try and get Californians to come and buy your product in Rhode Island. It just so happened that you were selling this product in Rhode Island to Rhode Islanders, and a California person happened to buy some. Under that situation, the person in California would have to come to Rhode Island to sue you. You have no personal connection with the court in California. They cannot drag you there for this type of scenario. And again, that seems to have to do with territory, and it does, but it has to do with the idea of, does this territory ever have any connection to this person? As a matter of fact, we call this in personam, personal jurisdiction. Now, the other aspect of personal jurisdiction is you must give notice to whoever's you're attempting to bring into court. So even if the person is here in Rhode Island, you can't just bring a court case. You must give them notice, and you must give them the opportunity to appear and be heard. And that gives the court jurisdiction over the person. And then thirdly, courts have subject matter jurisdiction. You cannot seek your divorce in the Superior Court in Rhode Island, because in Rhode Island, our legislature has, by statute, created a distinct court called the Family Court that deals with divorce, child custody, child adoption, juvenile criminal cases. You can therefore not bring your divorce into the Superior Court. Same thing, there is a workers' compensation court. So if you're injured on the job, you cannot bring an action in district court or the Superior Court or the federal court, because the subject matter of workers' compensation has been by statute placed within a particular court, and that is the court where you must go. So you have to look at all of these things. When a lawyer is about to bring a case in court, you have to look at all of these aspects and see, all right, am I bringing this in the correct court? And if you are not, the remedy is the other side goes into court and says, Your Honor, they don't have proper jurisdiction, and you get thrown out. You may still have your right to bring the case in the proper court once you figure out what it is, but you will certainly be delayed in what you are doing. Appellate jurisdiction is the idea that we have initial courts that we call trial courts. They are the courts where we have testimony and witnesses. We attempt to find the facts. The judges apply the law, or the jury sometimes will have to apply the law to the fact if it's a jury case, but that they make mistakes and that they sometimes do not do things correctly. And therefore, in all states in the federal system, we've set up a system of courts whereby you can appeal from the trial court to a higher court. On the federal level, these are called the circuit courts of appeal, right? On the state level, they have various names. In Rhode Island, we have only one appellate court, which is the Supreme Court. Although if you have a probate case in a town, or if you have a district court case, you can appeal to the Superior Court of Rhode Island. So in some situations, and from certain agency decisions, such as zoning boards and that, you can appeal to the Superior Court. So it's a little bit muddy. In Massachusetts, they do have an appellate division, and then they have the Supreme Judicial Court. So there is one intermediate court before you get up to the Supreme Court of Massachusetts. A docket is a list of activity in each case. It's kept by the court as a reference. It lists all the different hearings. It lists all the documents that have been filed. It may also list control dates when certain things need to be filed or not filed. It also can mean, in slang, in lawyer slang, when we say we docket a case, it means that the paperwork has gone to the court has applied a number to it, has opened up a computer file on it, and today, all the dockets are kept on computers in both Rhode Island and Massachusetts and the federal system. So if you needed to see the docket, need to see a list of all the different things that's been going on in the case, today you access that by computer, although they still do have paper files in many of the courts. So I suppose you could go and look at the paper file as well. Standing. Now we're getting into, let's go to federal question first. The next few things are different ways that the courts use to kind of limit what they're doing, to control how many cases they have, to make sure we're not hearing things just because of the sake of hearing them. And these particularly have to do in the federal courts, and one of them has come up very often recently in the whole contest over the elections. First thing is a federal question. Right? Federal courts, again, the Constitution gave certain areas of law to the federal government, and those are the only things that the federal courts are supposed to be dealing with. So if there is no federal question in your case, you have to take your case in state court. Now, you might potentially, after you go through the entire state court system, if you can establish that the state court under the 14th Amendment handled the state law in a way that deprived you of due process or equal protection, you might still be able to get into a federal appeals court of the Supreme Court. But again, at that point, you're stating that it was a state issue, but the way the state handled it violated my fundamental constitutional rights, and that becomes the federal issue. But just know that whole areas of the law, again, divorces, working compensation, challenging of wills, that they are not federal issues. They don't generally end up in the federal courts. Standing. This was one of the things that the courts used to throw out a large number of the election cases that were brought by Trump supporters and by the Republicans to challenge the voting practices in a number of states. Standing is the idea that only the person whose rights have been violated or who has been injured has the power to go to court. So if you were standing on the corner with your friend, a drunk driver comes along, comes up onto the sidewalk, hits your friend and injures him, but misses you. Your friend, when they get out of the hospital, says, no, I don't want to sue. I don't want to go after anybody. I've had it. No, the insurance company won't give me any money, but I just want to get on with my life. Even though you're outraged at this and you want to sue on behalf of your friend to see that your friend gets justice and compensation, you cannot, because you were not the injured party. Only the people whose rights have been violated or who have been injured are the ones who can bring a case. If anyone else tries to bring the case, the courts maintain that they have to throw it out and you have to find the correct party to bring it, or you can't bring the case at all. Moot is another issue that came up. The Supreme Court of Pennsylvania used this in a couple of election cases. Moot means the issue has already resolved itself for better or worse, one way or another, prior to you bringing this. In a couple of the cases where people were suing, saying the election in certain counties were not handled properly in Pennsylvania, the Pennsylvania Supreme Court basically said, oh, the election already happened, too bad, it's moot. So they really did not get into the issues of whether the election was properly done or not. They just said it's over, the Secretary of State has accepted it, we're done, we don't have to take this, we can go play golf today. Political questions. There are certain issues that the courts have traditionally said need to be resolved between the executive and the legislative branches, and therefore we are not getting involved in them. We're not dragging ourselves into that. And again, I don't know of any of the recent cases where they use that as a theory to get rid of the case, but certainly for the last 200 years, when it comes to elections and voting, very often the courts have said those are political issues. By the Constitution, they're given to the state legislatures. The state legislatures give them to the executive to administer, to run the elections. It's between them and their citizens to figure out what they're doing. We're not getting involved. There are various different legal theories today. A couple of the more prominent ones are the idea of judicial restraint. A lawyer or a judge who believes in judicial restraint believes that courts have a limited role to play. They must follow the Constitution, they must follow the written statutes, and that they are not allowed to really go beyond that. Judicial activism is the idea that the Constitution and even many laws were written long ago. They don't apply to our current situations and circumstances, and that it's up to the court to basically interpret, extrapolate, and to do what it needs to do, including reinterpreting the Constitution and constitutional rights based on present circumstances. So under judicial restraint, you're basically going to look back at what has happened before and try and keep applying it. Under the idea of judicial activism, you're accepting an idea more that, well, times change and the Constitution, the way we look at the Constitution, the way we interpret rights, has to change along with that. Both are applied by federal judges. Both are used by judges when they need them to get to a certain decision they want to get to in a case. And it's basically us law professors who argue about these things at this point. And sometimes the politicians trying to get votes will argue about them too. Precedent or stare decisis we spoke about in the first lecture. That is basically the idea that once a court hears a set of facts, makes a decision on that set of facts, they will make the same decision over and over again as the same set of facts comes up to them in the future at different times. Basically, the idea that court decisions and court cases must have consistency, that people should have some idea that once the court has ruled in a certain area, that the public and the lawyers will know what's going to happen in the future. And it becomes very important, and particularly in a system like ours, where the Supreme Court has the final right to interpret the Constitution and to say what is constitutional or not. And they early on said they had that right against the president and the Congress. And then under the 14th Amendment, they've now come to say they have that right against the state governments. This becomes critically important because basically once the Supreme Court decides an issue and hands down a case on it, that case becomes a law of the land for everybody, every federal congressional operative, every federal bureaucracy, every federal employee. It becomes a rule for all state governments and their employees and their bureaucracies. And it's very important. It has a great deal of power because it is a violation. To violate someone's civil rights knowingly is both a criminal and a civil wrong. So once the Supreme Court has handed down a decision saying that, well, this is, so-and-so has, this right exists, and it must be followed, any state or federal authority that goes against that runs the risk that they could end up in jail, and they could be sued by whoever they victimized by not giving them their right. So precedent has come to give our Supreme Court a great deal of power, far more power than most of the courts in other countries have. So in most other countries, the courts are pretty much subject to the control of at least the parliament or the Congress, and have to follow what rules they lay down. Here, it is not quite that clear, and our court has carved out for itself a great deal of power. Class action, very often there are situations, particularly, and these cases arose once people began to sue in mass manufacturing situations. So a company builds a car that has a flaw that after 5,000 miles, the brakes don't work anymore. And a whole slew of people are injured before they realize it and they pull these cars off the highway. Rather than letting 5,000 people bring 5,000 cases, lawyers can go into court, say, we represent several of the people who have been injured this way by this company. We want to bring a class action suit. The courts can authorize a class action. Then anyone who is injured in that situation with the same defendant, with the same company, they must now, unless they decide to overtly opt out, they become part of one case that hears all of this so the courts don't have to try this 5,000 times. These have become very popular among the lawyers because if you're representing 5,000 defendants and you're getting a contingent fee, a percentage of what they win, you're getting a very large number for your effort. So lawyers who do litigation, particularly in products liability, they look to try and find situations where they can turn a case into a class action. You'll see advertised very often on TV. Have you been injured by this? Did this happen to you? Did that happen to you? Call such and such. Those are law firms that usually have started class actions involving these types of cases, and they're trying to find out what plaintiffs are out there who they can represent in court. Amicus curiae, a friend of the court. We heard this term again in the cases about the election recently. And amicus curiae is somebody who does not have standing. They're not one of the litigants, but they may be affected in the future by the way this case would be decided. And they ask to have present arguments to the court just in case the lawyers representing the actual plaintiff and defendant don't cover all the issues or don't cover all the arguments. The courts, particularly the federal courts, have become very open, and again, particularly in cases that might approach political subjects or cases where civil rights of millions of people might be involved. The federal courts have become very open to accepting amicus curiae briefs, and so you will sometimes see civil rights cases where you'll have several hundred briefs filed by different parties, different agencies, all trying to make sure the court doesn't neglect their point of view when it starts thinking about how do we decide this case, how we're going to handle this situation. All right, that's it for this one. There will be more. Over and out for now.